Welcome to Jurisedge Academy's YouTube channel. In this video, we are going to talk about important weekly legal updates from 6 June to 11 June 2022. In first important news, the Supreme Court has dismissed the plea for special stray round of counselling in NEET PG examination. A two-judge bench in the case of Astha Goyal versus Medical Counselling Committee has held that when a conscious decision has been taken by the Union of India and Medical Council of India for not conducting any special stray rounds of counselling, it cannot be considered arbitrary. The court has also held that quality of medical education cannot be compromised, which affects public health. Petitioners are not entitled to any relief. Granting the relief now may affect medical education and health. In second important news, the Supreme Court has made some observations with respect to custody matters and has held that age, income, bigger family cannot be sole criteria in granting child custody. In the case of Swaminathan Kunchu Arya versus State of Gujarat, the court has held that income or age or bigger family cannot be the sole criteria to tilt the balance in custody matters. The court has held that there cannot be any presumption that the maternal aunt being married, having an independent income, younger than the paternal grandparents and having a bigger family would take better care than the paternal grandparents. The court has also made some observations with respect to how grandparents are more emotionally connected with their grandson. So it's a mixed set of reasoning which has been given by the court with respect to custody matters under the Guardians and Wards Act. In third important news, the Supreme Court has held that High Courts should not inquire if there is reliable evidence while exercising jurisdiction under Section 482 of CrPC. In the case of Jagmohan Singh versus Vimlesh Kumar, the court has held that while exercising jurisdiction under Section 482 of CrPC, the High Court should not ordinarily embark upon an inquiry into whether there is reliable evidence or not. The jurisdiction has to be exercised sparingly, carefully, and with caution only when such exercise is justified by the specific provisions of Section 482 of CrPC itself. It is important to note that Section 482 of CrPC deals with the inherent power of the High Court. In fourth important news, the Supreme Court has held that conviction cannot be based solely on the testimony of a wholly unreliable witness. In the case of Mahendra Singh versus State of Madhya Pradesh, while referring to Vadivelu Thevar versus State of Madras judgment, the court has held that there are three types of witnesses, that is wholly reliable, wholly unreliable, and neither wholly reliable nor wholly unreliable. So the court has held that if the witness is wholly reliable, the court should not have any difficulty in as much as conviction or acquittal should be based on the testimony of such single witness. Equally, if the court finds that the witness is wholly unreliable, there would be no difficulty as neither conviction nor acquittal can be based on the testimony of such a witness. Lastly, the Supreme Court has held that High Court should discourage writs when remedy is available under other statutes. In the case of Kotak Mahindra Bank Limited versus Dilip Bhosale, the Supreme Court has reiterated that the Supreme Court is consistently of the view and can be noticed from the judgment of United Bank of India versus Satyavati Tandon that when a remedy under the statute is available and in the instant case which indeed was availed by the respondent, filing of a writ petition under Article 226 of the Constitution is to be discouraged by the High Court. This brings us to the end of our weekly legal update. If you like this video, please like and share and subscribe to our YouTube channel.